Good morning, Mr. Ford.
Chief Justice Marshall, Your Honors, good morning. My name is Michael Ford. I am here representing the appellant, Joseph James Marzili. With me is Attorney Terrence Kennedy. We're here because a Superior Court justice doubts that an attempted indecent assault and battery is a crime in the Commonwealth. And the justice has this doubt in light of the findings in Commonwealth v. Eaton. I would suggest that a decision for the appellee would overturn hundreds of years of jurisprudence in the Commonwealth.
As the Rule 16 letters indicate, this particular crime has been prosecuted not infrequently.
Yes, it's been,
and it is mentioned in the sex offender registration laws.
Well, with respect to the first part, the Rule 16 submissions, the particular issues that were before the courts there were different. I believe the first one that was submitted dealt with a sentencing issue. The other one dealt with the admissibility of evidence. So I would argue to Your Honors that those cases don't deal with the issue of whether or not the crime of attempted indecent assault is a crime at all.
But why can't there be an attempted unconsented touching?
An attempted unconsented touch, well, if we go to the definition of assault, the definition of assault, which drives this, is that an assault can be accomplished in one of two ways. The first way being an attempted battery. The second way by putting another in fear of an immediate battery.
I know all that, but just thinking about it as a practical matter, why can't someone try to touch somebody in a sexual area and not succeed? And isn't that an attempted unconsented touching if the person on whom the attempt is made doesn't consent?
And that's what the Commonwealth has actually, and that's what they've charged, by
Right.
charging
Well,
the
so
attempt statute.
why is that? Why do you think that's not possible?
Well, there's a couple of reasons. The definition of assault, by applying the definition of assault to the attempt statute, which is what the Commonwealth wants to do, and let me back up to answer that question. The Commonwealth is utilizing 274 Section 6, the attempt statute, to criminalize something for which the legislature hasn't criminalized.
But it has an attempt
Well, they think
statute.
they have.
It has an attempt statute. That does criminalize attempts.
Exactly, Justice Cordy. That if a review of the Chapter 265, Section 13A et sequitur statutes would show that the legislature has been very careful to spell out various disjunctive.
The legislature certainly thinks they've created this crime because they've listed it as a crime for which you have to register.
However, on that opens a door. They would argue that you just absolutely can't do. That would be a criminalization by implication, which
No.
You're saying the statute's unconstitutional? The registration statute?
What I'm saying is this: is that on the if the underlying crime, well, the registration statute has a catch-all. We're going to have you register for all these crimes. But if the underlying crime is found that's listed is struck down as not a crime, then the collateral punishment, the registration, would in turn fail.
If the crime had been indecent battery, would you be here today?
If the crime had been indecent battery, we wouldn't be here. There'd be a touching,
Okay.
And of course that would be an indecent assault.
But
battery.
isn't it an indecent assault and battery? The word assault and battery is really just a misnomer. It has to be a battery, doesn't it?
Well,
Isn't that what it's all about?
Well, I think it's some of the case law that I cited. I don't recall the name of the case, but implicit in every battery is an assault. I would argue not the other way around.
But for an indecent assault and battery, I mean, that's what Eaton is saying. An indecent assault and battery basically is the battery. So if you have an attempt, it is, as Justice Pia is saying, it's an attempted battery, right?
Well, I would argue that Commonwealth v. Eaton is saying that an assault of an indecent nature without a battery is only a simple assault or a common law assault.
But that's not taking into account attempt.
It's not taking, well, the attempt would basically undo the very definition of assault being an attempted battery.
If I see somebody, or if someone sees a third party sitting in a chair sleeping and wants to wake him up and says to somebody next to him, says, "Watch this," and he picks up a water balloon, throws it, and misses. Person who's sitting in the chair has no idea, because he was sleeping, that the water balloon brushed by his ear and hit the ground. That's an attempted battery, isn't it?
That would be an assault. That would be, that's
You're saying
that's
an assault is, you know, in the CPCS, it's an attempt of an attempt. The assault is the attempted battery. So you're asking us, the Commonwealth says you've got to have an attempt of an attempt. If it's,
You can't really assault somebody who's asleep, can you?
I would suggest they would under that definition, they would have to be aware. For it
Yeah,
to-
so it's an
under your-
attempted battery. What I propose is an attempted battery.
No, and I stand firm on that. No, because the legislature has already provided the statute, it has already provided for the criminalization of that at Section 13A, which is an assault.
Now, isn't your argument based on the common law of assault and battery?
And to speak to that, it has to. Although the Section 13A statutes outline the various types of, assault and battery, we have to look to the common law definition under Commonwealth versus Slaney. There's no specific definition of it in the statutes.
But isn't there a problem in that there is no common law crime of indecent assault and battery?
There is no common law crime of indecent assault and battery. The Commonwealth, I believe, concedes that, but that doesn't in any way undo well, I'll rephrase it in a different way. In this particular case, you have an attempted battery, and I would argue to Your Honors that just because you put the word indecent in front of it doesn't change anything. You're still driven by the common law definition of assault being an attempted battery.
But I mean, it's one thing to say that if you merely charge assault and battery, and it's an attempted battery, then it should be the lesser included crime of assault. But here, they've charged a special kind of assault and battery, which is indecent assault and battery, which has another element, a sexual touching. Why would the lesser included of a mere assault be sufficient to address the attempted sexual touching?
If I understand your question, is that when it's combined with the actual, is what you're asking, is that when it's combined with the actual attempt statute?
They used the attempt statute here and charged it in order to essentially say what we have here is an attempted sexual touching, which is more than an attempted battery because it's attempted sexual battery.
Well, using that, the sexual touch, that would be an added element. Just an added element to the underlying core elements of an attempted battery, and I think that can be answered, at least answered in part, as in the Commonwealth, in the instant case, they're attempting to they're criminalizing an indecent attempted battery through an attempt statute, and you can't go to the lesser included there because the underlying crime of attempted indecent attempted battery is not a crime at all. Returning here once again.
May I, if I'm following you, you say the legislature has really not created an offense of attempted indecent assault and battery, right?
They have not.
Have not.
Have not.
And is there legislative history to suggest that they thought about it and said, no, we don't want to do that?
I can't speak to that except for the fact that Commonwealth v. Eaton was decided in 1974, and as it stands today, as it stands at the time that the appellant was charged, there was no such charge of attempted. No such charge as indecent assault.
So what do we make of the fact that they require people who are charged as sexual offenders to have to register if they're charged with indecent assault?
Well, two points I would raise to that, Justice Island. First, it's a collateral punishment. It fails if the underlying fails. But also, I think with the collateral punishment set, the registry, it was attempted indecent assault and battery after being convicted of one or more indecent assaults in battery. I would also what I would also say to that is what's been positioned here, what's been what the court has raised, I would suggest, is really an ambiguity. There's a major ambiguity here, and if we go to the case law at Commonwealth v. Lupo and Commonwealth versus McLaughlin, all ambiguities have to be resolved in favor of the defendant.
You do not have to use up all of your time. In fact, you get extra points.
I think I think we're taking a look at all the points. I think that we have made all the points, but I'll just sum up in turn. And so you have two questions in front of you, and the appellant asked the court to answer the first reported question as a no. We ask that you find that there is no crime as attempted indecent assault and battery in the Commonwealth, and with respect to the second question, that you answer that the crime is therefore a nullity, and I thank you.
Thank you, Mr. Ford. Ms. Stevens?
Good morning, Your Honors. May it please the Court. My name is Bethany Stevens, and I'm an Assistant District Attorney from Middlesex, and with me is Elizabeth Dunnigan, and she's the trial prosecutor in this case. The defendant's argument that the fact that there is no crime entitled indecent assault actually supports the conclusion that we properly charged an attempt to commit an indecent assault and battery under the attempt statute. The plain language of the statute actually says whoever attempts to commit a crime shall
Can you just slow down just a little?
The attempt statute actually provides that whoever attempts to commit a crime shall, except as otherwise provided, be punished. If there was a statute out there that otherwise provided, we wouldn't be charging under the attempt statute. This is not a situation where the legislature needs to specifically identify a crime in order for you to go under the attempt statute. That just wouldn't make sense, because then we wouldn't even need to utilize the attempt statute. The defendant is suggesting that all of the times that the legislature prescribes a crime by using the words assault and battery, they are therefore precluding charging that crime as an attempt. The only thing that you could do if you had somebody, a defendant who tried to commit the crime and didn't complete the crime, the only crime we could charge him with is a straight misdemeanor assault, is just untenable. And what that would require is looking at defendant's brief from page 18 through 20, the list of the 265 crimes. Assault and battery to collect a loan. If somebody attempted that, you could only charge them with assault. You couldn't charge them with attempt to commit the crime of assault and battery to collect a loan. Assault and battery upon a public employee, indecent assault and battery on a mentally retarded person. If you had situations like that where a defendant was unable to actually complete the crime, defendant is suggesting that all we could charge them with is assault, and that's just an untenable position. It is clear that the legislature did intend that if you aren't able to complete a substantive crime, like we have here, indecent assault and battery, you can charge that crime under the attempt statute. Looking at the Eaton case here, where the Justice and Defense Counsel is asking his court to look at the Eaton case, Eaton speaks to a lesser included offense. We're never going to be looking at attempts when we're talking about looking at lesser included offenses. This court has made clear in Commonwealth versus Gosselin that because of the overt act requirement that's required in the attempt, you can't have a lesser included attempt or lesser included charge of attempt. So the fact that Eaton didn't speak to the attempt statute means nothing. It sheds no light on the attempt statute whatsoever. I just wanted to quickly say, too, as far as the amicus brief, when they are characterizing the charge here as an attempt to assault, an attempt to commit an attempt, that's a mischaracterization. We are not charging that here. We are charging an attempt to commit a battery. This court's made clear in Commonwealth versus Burke that the name assault and battery, that's used in the indecent assault and battery statute to mean a specific type of battery, an unconsented battery. It's a criminal battery. They've called it an indecent criminal battery. We have here an indecent unconsented touching. There was an attempt to indecently, without consent, touch the victim. It wasn't completed, and therefore it's properly charged as an attempt. There's no legal impossibility to attempting to commit the crime of indecent assault and battery, and there's no impossibility to charging that crime. I think that's all the points I wanted to make, unless there's questions.
Thank you, Ms.
Thank you,
Ford.
Your Honor.
I mean, Ms. Stevens.
Thank you.